Hey, good evening. I'm Dan Zimbroff, an attorney with Barker Martin, and this evening I'm going to be speaking some legal issues for homeowner associations. I entitled this The 5 L's That Should Keep You From Filing a D&O Claim. D&O claim is a directors and officers claim, and this title came from a few years ago. I was talking to a board president, and she said, you know, I'm really nervous about being president. I've never been on a board before. So I've got 2 goals. One is during the 2 years I'm a board president, we don't get sued and no fist fights break out in a board meeting. I thought, wow, that's a pretty low threshold. You know, good luck with that. Hopefully, you know, after you feel a little bit more comfortable, you'll raise the bar just a bit. So the 5 L's that we're going to talk about is, first of all, the legal structure. When we're talking about homeowner associations, condominium associations, we got to kind of paint the picture and let you know where you're working off of. This isn't just you know, although sometimes some of the stories I hear, it does sound kind of like a high school student body association, but it actually is a legal entity. We'll give you the structure about how we're working on that. Board meetings are pretty important, so we're going to go into some detail about that, since for associations as board members, that's where you should be conducting your business. We'll talk a little bit about laws. You know, I'm a lawyer, so I'll try not to get too much Latin in here, but we do probably just a little bit. And that's why, by the way, I'm last, is in case you're not tired enough working all day and listening to, though Kathy and Lynn were quite active, and I didn't see anyone nodding off, but I'll try to keep that pace going. Liability, because I assume as a board member that's something near and dear to your heart. You want to make sure that you don't step into any legal pitfalls. And then talk just a little bit about legislation, because there are some areas. We've already touched upon one question, and Michelle talked about the manager certification, so we'll describe that. Now, the mantra that I came up with is, if you take nothing else from tonight, my 20 minutes, 25 minutes, whatever we have, it's follow your documents, follow your documents, follow your documents. Lynn had said, and I think Kathy had mentioned about document, document, document. Well, that goes both ways from a lawyer, right? If there's a bad document out there, you would, you know, might want to get the shredder rather than have the document. No, I didn't say that. But hopefully you've got good documents, and then follow your documents. Because I agree with Kathy that barely a day goes by that I don't get a phone call or I don't hear about something that is interesting, is different, and that's really what makes my job so terrific. I mean, I work with people and their investments and their homes and the emotions, as we all do in the industry. But I have to say that no matter what I hear, no matter how strange it sounds, I can almost guarantee that the answer is there in the holy grail of the documents, either the statute or the governing documents. It may not say that, it may not highlight, you know, this particular pet issue, but if I look in the section that talks about pets, I bet you that I can interpret your governing documents, as long as they're good governing documents, and the answer is going to be there. So that's my mantra, is follow your documents, and follow your documents. What documents are we talking about? Well, we have some statutes in Washington State that I've got a slide that we'll talk in a minute, so I don't want to jump ahead too much. But that's going to be where you look to first, is what does the statute, what does the legislature say? What do the courts say? So you have the statutes. And then you've got the governing documents. So let's go through some of these. Oh, by the way, unlike Kathy, please don't interrupt me. I just want to drone on for the next 20 minutes. Save your questions for the end, or probably be better yet on your drive home, all right? And then we'll just get through this pretty quick. No, seriously, please do, if you have questions, if you just have comments, as Kathy said, I think it's more helpful if you've got some interaction. All right, so the governing documents. For the bonus, who can tell me what CC&Rs are? What does that stand for? Covenants, conditions, and or restrictions. All right, we'll give that to you. But all right, so what does CC&Rs mean? The legal definition of CC&Rs are really going to be in the declaration, and that's what's recorded. But sometimes you hear the reference to all the governing documents as CC&Rs. But for purposes of a strict legal interpretation, CC&Rs are going to be the declaration. But before we get to the declaration, let's talk about the Articles of Incorporation. Because I believe all of you are incorporated, correct? Nonprofit corporations, any for-profit corporations? Okay. So you were created, the association, the nonprofit corporation association was created by recording with the Secretary of State your Articles of Incorporation. And those were provided. And Most often I've seen in Washington, in our area, that the articles are pretty bare bone. There's not much substance in those. However, every once in a while, you do find, or I do look at and can see that they throw in some provisions that you might ordinarily see in bylaws. So if you haven't already, if you're sitting on the board, make sure you've reviewed at least once your articles of incorporation and make sure there's nothing strange that's in them or nothing of substance that deals with your everyday business as a board member.
If you have a certificate of incorporation, is that all you need?
Well, it is to start, but then you need to, well, your certificate is what the Secretary of State provides to you. So initially there were some articles that were recorded with the Secretary of State. They can be amended from time to time. And you also have to make sure that you renew your registration with the Secretary of State annually as well. And that's, I think it's like $75 approximately for nonprofit corporations. So you've got your articles of incorporation that allows you to conduct business with the state. Now you have a declaration that was also recorded. And a condominium, unlike a homeowner association, is a creature of statute. It's only created by the recording of the declaration. Whereas a homeowner association, a PUD, a development, residential development, is created, through the homes and the deeds and the plats. But a condominium, because of this shared ownership concept, is created through the recording of the declaration. Now, earlier, before we started, there was a question or a comment by this lady about the name of her association. She said, well, it's a condominium. It's in the name, and I'm sorry, what's the
Condominium Homeowners Association.
right, but what's the specific name?
Oh, you mean where I live?
Yes.
Rainier Crossing.
Okay, so it's Rainier Crossing Condominium Homeowners Association. Well, are we a condominium or are we a homeowner? Because we've got both in the name. You see that sometimes you see just homeowner association, Rainier Crossing Homeowner Association, that's a condominium. I haven't yet seen a Rainier Crossing Condominium Association that's a homeowner association, but I wouldn't put it past the developers. The bottom line is you have to look at the declaration to see officially what type of association you are. Don't go just by the name. So in your situation, you are a condominium association, even though you have the name homeowners in it.
On the certificate of incorporation, it says Condominium Homeowners Association.
If you look to your declaration, I'm going to assume maybe this was the first time I said that I haven't seen one yet that had the name condominium that was a homeowner association. But if you look in the declaration, it should say a condominium, and it should refer to the condominium statute that we'll get to in a moment. So do you believe that you are a condominium?
That's what the certificate says. But
Okay.
can I ask, I've been on the board for 4 months, and I know we have bylaws, I know we have CC&Rs, I know we have rules and regulations. I know there are some resolutions, but I have never heard of or seen the articles of incorporation or a declaration. Where would they be?
Okay, so her question was, she's been on the board for 4 months, and she's seen bylaws, she's seen rules and regulations, CC&Rs, so that's declaration, but where would the articles of incorporation be?
What did you say the declaration is the same
Well,
as what?
it should be the same as the CC&R. So the title of the document many times will include covenants, conditions and restrictions, and declaration, and then a condominium, all in the title. Sometimes they leave out the CC&Rs, covenants, conditions, restrictions, and just say a declaration. But if you have if your document says the CC&Rs, and I'd be surprised if it doesn't somewhere say declaration, but as long as that's the document that's recorded, then that's going to be serving as the declaration. Your articles of incorporation should also, as long as you can check on the Secretary of State website, key in on corporation search, put in the name, and you can just do this for free, and it shows up the status of your corporation, your association. And as long as the Secretary of State shows that you are a valid corporation, then at some point articles were filed. What I recommend is each association have a corporate book. Just as Kathy said, you are a nonprofit corporation, many times multi-million dollars of assets. You should have a corporate book that has all of this together. And if you're professionally managed, your manager should have a copy. The board should also have a copy. If you're not, if you're just run by self-managed, then the board should have that. And it should also have each of these documents. So the question is, when you purchase a unit and you're given CC&Rs or bylaws, are you also given articles of incorporation? Well, when you purchase a unit from an individual, there is not a requirement to be given any of these documents. When you're a first purchaser for a condominium, you are, but for subsequent purchases, you're not. It's good practice, and we highly recommend that associations do that, so that they are and many times people rely on closing, an escrow for the realtor to do that. But we recommend that the association have a policy and make that affirmative duty, and you can charge, whatever the reasonable charge is for that. But yeah, have that book that has all of that, and including having to update the rules and regulations. So that's what we would recommend. Yes, sir.
You're really close. I've got a question real close to that from a homeowners association, where anyone coming in buying a home, I remember basically I was by the other homeowner just simply given some papers and say, oh, by the way, here's your CC&Rs. How prudent is it to have the board or the management association have a signed document that says, yes, I have received and I have read and received and understand the declarations, bylaws, CC&Rs for this HOA?
For a homeowner association, is it prudent to have an acknowledgement form when a new purchaser or a new member of the association purchases a home that acknowledges that they've received the documents and can list what they are? Sure, I think that's a prudent thing to do. Is it legally required? No, but as Lynn started with good governance, good leadership, good community, that's a perfect way to do that. Where do you do that? Do you require that? The practical effect is that you've got to be proactive with the agents so that they make that part of the closing at escrow. Short of that, you could have some type of welcoming committee. If you see someone that moves in, then the board or committee can come by, welcome them. Here's your booklet. If you're going to be charging for that, then it's a requirement. That should all be in some type of rule or resolution so that it's out there, especially if you're going to be charging for it. We'd recommend you do that.
If they don't see or sign off or agree to those CC&Rs, how can a board turn around and hold someone accountable for, okay, you have a trailer parked in front of your house or a boat, and we're sorry, you bought this house and you agreed to not have your boat or trailer parked in front of your house?
Yeah, great question. So his point is, or his question is, can you still enforce the governing documents if the individual did not acknowledge them, or maybe they didn't receive them at closing, which actually happens quite often? Yes, you can, and the reason that you can is because these are recorded documents. At least the declaration is. The declaration many times has the restrictions. Now, we haven't talked about this, so let's talk a little bit about it. So I'll answer your question directly in just a moment. So you got the declaration. The declaration is more of the Constitution. It's kind of the authorizing, giving the authority to the board, and steps through some specifics. The bylaws are a little bit more of the day-to-day actions. It talks about officers, meetings, notice. So more of the day-to-day interactions of board business. And then the rules and regulations are accompany the declaration. So the declaration should give you the broad purview of particular restrictions and covenants, and then the rules should really fill in the details. And the reason why you have two separate mechanisms, the declaration and the rules, is because a declaration, to actually amend it, is going to take a minimum of 67%, sometimes higher, of the association. So it's burdensome, it's costly to amend that. You don't want to have to amend it every time if you're going to change your pet policy for the size of a dog or parking. So that normally, when you get to that level of detail, is done in the rules and regulations. And the rules and regulations, resolutions, are governed by the board. So the board doesn't have to get approval from the homeowners to adopt or to change rules and regulations. So the declaration's recorded. So the owner is put on notice, or the purchaser is put on notice, that, yes, you are buying into a homeowner association, and the homeowner association has these certain rules and restrictions, covenants, conditions, and restrictions. So title companies pick up those recordings in their title search. So the owner doesn't have an excuse. I didn't know this was an association, or I didn't know there was this rule. Well, the courts have interpreted that because they're recorded, you are known, or you are expected legally, you are required to have that. So as long as the declaration was recorded properly, and as long as the rules and regulations or resolutions were adopted properly, then there's no requirement to have an owner acknowledge on their own. Does that answer your question?
Just about, so you're saying that the title company must give the CC&Rs to the purchaser, whether they sign off on them or not. They, by purchasing the home, have received them and will have to live by them.
The gentleman's question is, did I say that the title company is required to give the governing documents, and because of that mechanism, they're not, the homeowner is not required to acknowledge? No, what my point is that the court, similar to a lien, if you're purchasing a home and there's a lien, or a duly recorded lien, then that's going to be assumed that there's a mechanism in place through title companies to pick that up, to notify the purchaser that, hey, there's a lien that's on that. And the courts have construed that as a reasonable and appropriate mechanism to protect a buyer, to say, hey, we didn't know there was a lien. Well, there was a lien, it was properly recorded, then you're going to be duly reason to have notice. It's similar to the governing documents. So practically what happens is the title companies pick that up, notify, in the title report, the realtor picks that up and provides it to the purchaser. So if someone's buying into a homeowner association, that information will pop up. And then if they are doing their due diligence, they'll say, oh, okay, well, I should get a copy of these declarations and rules and regulations and see what I'm buying into. Okay. There are sometimes master and sub-associations. So if there's a combination of either multiple homeowner associations, or maybe a condominium and a homeowner association, then ordinarily those are going to be sub-associations, and the overview is going to be a larger master association. And so ordinarily a homeowner would be a member of both. They'd be a member of their sub-association and also a member of the master association. We see a lot of those master communities in our area here. Okay, governance. So these associations are governed by board of directors. Lynn went into that in quite detail. You've got board of directors. Now, if you look at a Fortune 500 company, normally you're going to have different individuals as officers than board members. You're going to have a board of directors that oversees the officers. Well, we know practically it's hard enough getting enough volunteers on a board that really are we going to get board members and officers? No. So you got the dual hat. If you look at the bylaws, you're actually having board of directors votes, elections, and then the board members. So homeowners are not electing a president or vice president or treasurer. They're electing the board members, and then the board members decide then internally if they need to vote as to what position they're going to hold. Committees. Committees are a terrific mechanism and vehicle, especially for associations where there might be some infighting or might be some conflict. What better way than to allow the people that are really creating the biggest fight to go get a committee. One of my strongest suggestions is, if you're going to use committees, make sure at the outset that they understand that except for rare instances, committees are advisory. They're just advising the board. The board still maintains the responsibility and the authority in the final decision making. One exception to that might be an architectural review committee for homeowner associations that actually has some decision-making authority to approve or deny an architectural request. But even in those instances, there's going to be some board members on that committee, so it's normally going to be a mix. And there's some laws that govern that as well. So make sure they understand and specifically what their marching orders are, and that the board maintains that ultimate authority. And then agents could be the manager, could be an attorney, it could be a CPA acting on behalf. You want to make sure that that's in some type of written contract. Just because someone is saying that they are a manager and is representing to the community out there that they are managers can get the association in trouble. So if the association is going to rely on managers or agents, then make sure that there's some type of contract. All right, so any questions to this point on statutes or the governing documents, the authority on governance? Okay, so let's talk a little bit about the board meetings, because this is an area that sometimes board members, especially new board members, might run into some trouble. Let's maybe start almost in the bottom up, and that is, in this day and age of technology, of email, of cell phones, of people being pulled in 18 different directions, what we see quite often is board members that want to conduct business outside of just a regular board meeting. You know, how easy it is to just shoot off an email and talk about the landscaper or the landscape contract. Oh yeah, what do you think? And should we hire this? You know, the manager comes, and before you know it, you've decided on which landscaper to use outside a duly authorized meeting. You're smiling because you've seen that happen, I'm sure. So from a legal standpoint, I'm going to tell you, be careful. You shouldn't be doing that. Now, is that to say you can't email another board member? No. You know, hey, what time's our meeting next week? Oh, it's 7 o'clock. Ooh, wait, that lawyer said we're conducting business. No. It's if you're making any decisions, if you're discussing substantively what that board business is. And it makes sense. Why not? Why can't you do that? Why can't you use email to do some business? Because you're not having an open meeting. Now, in Washington, for a condominium, are you required by law to have an open meeting? Actually, you're not. If you're a homeowner association, you are. But in Washington, now, your governing documents may require it, and many times they do. But by statute, and I haven't figured that one out, why they don't require it. They do for HOAs, but not under the new act. But it's good practice, right? You want to be transparent. You want to have open meetings. You want to provide proper notice. Look to your governing documents, primarily, most likely in your bylaws. Have an agenda. What happens if someone comes to a meeting, a board member, and says, hey, I really think that idea about filling in the pool that Lynn said, because no one's using it, I think it's a great idea. I think we should talk about that. One of the other board members says, you know what, I've been thinking about that the last month too, and I heard a couple of homeowners say that. Yeah, let's start talking about that. And you vote and say, we're all in agreement. Let's fill in the pool. Is that good? No. Why not? Because it wasn't on the agenda. It wasn't proper. So, but why does it have to be on the agenda? Well, to document, right, but also if you think back at the whole idea behind having an open meeting is provide an opportunity, you want transparency. And let's say there's a homeowner that does get up at 6 a.m. and swim. And ordinarily they weren't going to go to that board meeting, because who goes to the board meetings? But this one, if they known that, hey, the board was going to discuss filling in the pool, they would have been there. So although you may think that that's handcuffs or constrains the board too much, legally it's very important to make sure that business is conducted per the agenda. Quorum requirement. In Washington, there is a minimum by statute. It could be higher by your governing documents. So for condominiums, it's 25%, and for homeowner associations, it's 34%. 25% for condominiums and 34% for homeowner associations. Now, your governing documents most likely may have that higher. So if it's higher, you go to your governing documents. So what happens if you can't reach a quorum? How many of you have had difficulty in an annual meeting reaching quorum? You folks, well, you folks are lucky. So what have you done?
We do proxies.
Okay, excellent. But proxy officially does count as quorum. So as long as they're done properly, then they are counted for quorum. And then conduct. That's pretty much what the point that I wanted to make here is that you're conducting business at the duly noticed and agendaed board meeting. How about homeowner participation? How many of you recommend and facilitate homeowner participation in a board meeting? Good? Ooh. How do your meetings go?
Not
15 minutes.
Do you give them 15 minutes?
Yeah.
Okay, great. So you've got a designated time period and limitation. Okay, excellent. Any other ideas there? Okay, perfect. And that's the point, is it is a board meeting. It doesn't mean it's a free-for-all. It doesn't mean that the homeowners participate. I love, one of my favorites is, when one of the first things you do is going to approve the meeting minutes. Vote for meeting minutes, and the homeowners vote too. Well, no, it's the board. Thank you very much. Appreciate you showed up. Really glad that you're participating, but actually this is a board meeting. Yes.
I have a quick question about. I thought you were speaking specifically about board meetings, but then you were talking about a quorum, and then in relationship to an annual meeting, which is different. You're not talking about quorum of homeowners at a board meeting, are you?
No, but good. I was just making sure you're awake. I was just going in different directions, but no, you're right. Normally, the quorum for a board is just going to be the majority of board members.
Okay, I just wanted to be clear that we weren't doing something wrong. Because mostly nobody comes to our board meetings.
Yep.
Okay.
Yep, and there's whole topics that we offer, this chapter offers, on how you can improve participation, how you can run efficient board meetings. So once again, tonight we're just giving you just a tiny slice, but there are sessions, Saturday seminars, evening seminars, Community Association Day, Law Day, a lot of information, a lot of opportunity to delve a lot deeper. And we talked about email. So any questions on board meetings? Yes?
Notice, the first one, depending on your bylaws or your CCNRs, that tells when you post notices for the meetings. Now, the agenda, normally at the board meetings hours, we have an agenda in front of the board members. Should we post the agenda at the same time we post the notice for the meeting?
Your agenda, whether it's a homeowner association meeting or a board meeting, ordinarily your agenda is going to be included in the notice. So it's not just going to say, notice of board meeting. Right. Now, so let's talk two separate ones. If you're talking about a homeowner association meeting that's going out to all the homeowners, then yes, the agenda definitely needs to be in that notice.
Is that documented somewhere?
Is there a statute?
That I can refer to show it to my other board members instead of me just saying it needs to be documented?
No, but that goes to more of court interpretation. But if you look to your governing documents, there may be very specific and specified other than just the time period for notice. But if not, to do it properly, you want to have the agenda ahead of time, and what makes most practical sense is to have it part of the notice so you're not sending out two different documents. And it might be confusion as to, well, what's the official notice, the agenda or not. If it's just a board meeting, then, and you're not relying, there's no involvement with homeowners, there's no vote that board members are going to be, you're not combining an association meeting with a board meeting, then as long as the board members have an agenda ahead of time, you don't necessarily have to have the agenda with the notice to the homeowners if your governing documents are requiring an open meeting, or if that's your business. Personally, I think it makes sense to have the agenda on the notice so the homeowners that are interested can show up, but strict legal interpretation, you wouldn't necessarily have to have the agenda as part of the notice to homeowners if it's just a board meeting. But the board members themselves should have that agenda ahead of time. Does that clarify it? Okay, well, I'm happy to talk to you afterwards then.
I mentioned that the board members at the meeting have the agenda in front of them as part of the packet,
But when did they, so she said the board members have as part of the packet in front of them at the meeting the agenda. When do they get the agenda?
Normally the night of the meeting.
Okay, so that's the problem. She said normally the night of the meeting they get the agenda. To be perfectly legal and dot your I's and cross your T's, the agenda should be provided to the board members as part of a notice, whatever that time period is that's in your governing documents as to when notice of a board meeting. Now, normally notice of a board meeting is going to be much less than notice of a homeowner association. Normally it's 10 or 14 days, no greater than 60. Board meetings, many times it can be down to 3 days. And in fact, board meetings or HOA meetings, you can have emergency ones, for less. So there are circumstances where you could be less than that, but they have to meet the threshold of an exigent circumstances or emergency.
So if you publish a notice on the mailboxes or whatever that you're having a budget ratification meeting in 2 weeks, which is the normal time to post that notice, should the agenda be posted at the same time that notice is posted?
Oh, you just threw a wrench in that question. She asked, well, if you're providing notice of a budget ratification meeting, does it have to be in? Actually, a budget ratification meeting for both homeowner associations and condominiums are meetings of the homeowner association and not of the board. So definitely in that circumstance, you are required to have the agenda, that budget ratification portion, as part of the notice. Does that make sense?
I like that answer very much.
Okay.
My only problem is I need documentation.
Well, that one I can help you with. That is required by statute as far as the budget ratification process. Unfortunately, tonight, that's an area that we're not going into detail. However, if you join CAI, in fact, we're right. Michelle, did we just finish the budget process? We just finished it, but I'm sure we can get the answer for you in a presentation. Oh, I'm going to whip through this one really quick. This is primarily for your reference if you want to go back home and having trouble sleeping and you want to look at some statutes. There is the Nonprofit Corporation Act that would apply to both homeowner associations and condominiums. Now in Washington, then there's the Condo Association. So for condominiums prior to July 1st, 1990, it's the old Horizontal Property Regimes Act. For condominiums, July 1st and after 1990, then it's the New Condo Act, 6434. Those are, especially the new act, is fairly robust. There are some provisions of the old or the new act that apply to old act, but I'm not going to tell you what those are because it's pretty detailed. And then the HOA Act is about that thick right there. It doesn't tell you a whole lot. It tells you what flags you can put on a common property, but if you're a HOA, then you probably already know that. Now, there's also a lot of federal acts that apply. So, yes, sir.
What's RCW stand for?
Revised Code of Washington. That's the statute. So if you want to just do a Google search, that will pop up, and you can look and see what those statutes are. So it's free. It's online if you just do a Google search. There's Federal Telecommunications Act. Do you think that applies to associations? Where might that apply? Dishes, right? Oh, wait. We want to restrict satellite dishes. Can we? Got to be careful because there's a federal statute that's going to preempt your governing documents. Fair Housing Act, where might that come into play? If you are going to any type of rental restrictions, potentially can, along with the American with Disabilities Act. If you've got some physical, issues, parking issues, Landlord-Tenant Act. One that I don't have on here that actually is quite topical these days, the Fair Debt Collections Practice Act, if you're going after for collections. So there are several federal statutes that apply to homeowner associations and provide some pitfalls for the unwary. Keep me in business. Okay, liability. Standard of care. How many of you as board members have a fiduciary duty to your association? Oh my goodness, this has never happened. Really? You guys are smart. So what, all right, now to really pass the test, what is fiduciary duty?
I don't know, but I ain't got it.
Good. So fiduciary duty, it's a heightened duty. It's a heightened standard, and it's going to be created either by statute or by contract. And in Washington, for homeowner associations or condominium associations, the only individual board member that has a fiduciary duty is for a condominium, a new condominium that's created by the declarant, and the declarant appoints a board member during the period of declarant control. Once the association is turned over to control the homeowners, then the fiduciary duty goes away, and it's just a basic business judgment rule, which means ordinary reasonable care. The example I use is, let's say Jeff Bezos, CEO of Amazon, decides he wants to become a president of his homeowner association. So he's sitting on the board, they take some action, a homeowner is disgruntled, sues the board, sues Jeff Bezos, and says, Jeff Bezos, come on, you're the CEO of a Fortune 500 company. You knew better than that. Is he going to be judged as a CEO of a Fortune 500 company? No, he's going to be judged as a layperson, volunteer, homeowner board member. So that's all you have. Insurance, I started the title of the slide with D&O. You should have directors recommend. You have directors and officers, liability insurance. So in addition to just the general business condominium association, that's added protection for board members, for committee members, potentially for agents. There's an indemnity provision, I would bet, that each of your declarations contain that says there may be some restrictions on even the ability for a homeowner or someone to sue you individually. They may have to sue the association in lieu of you individually, but even if you are sued individually, indemnity means the association steps into your shoes and should provide a legal defense and any indemnification, any money if it were deemed that the board member was liable for damages. So you've got two levels of protection. You should have insurance, and then you should have the indemnity provision. And that's why you're all sitting here, because if you didn't have that, you wouldn't be sitting here, because no one would step up because of the great salaries that you get as board members, right? So at least you've got the protection from legal. Now that doesn't mean you couldn't get sued, right? We live in a litigious society. It doesn't stop people sometimes from suing individually, but you just turn it over to the insurance agent or to the association, say take care of that. Special assessments have been cause for some liability on boards. They don't necessarily understand that process or understand following their governing documents. The takeaway there is look to your governing documents if there's a provision for special assessments. If not, then handle it just like any other budget ratification. Have that process. Contracts, I think Lynn did a good job of covering that. Recommend definitely that you have some level of legal involvement there once you've got the contracts. And then loans as well. And the gotcha there is the banks are good about that now through recent underwriting changes. And what I've seen lately is they're requiring, before the loan will close, they will require an attorney certification saying this board has authority. Some boards in the past have gotten into loans without having the proper authority and opening themselves up to liability. The other point there is, if you're going to, before you sign contracts, whether it's a major renovation or a capital improvement, it's not enough just to pass a special assessment, but you've got to, and you don't necessarily have to have the money in the bank, but there's somewhere in between where you've got to have something more than just the imposition or the adoption of the special assessment. If you've got a loan, once the loan closes, the money may not be in the bank, but if you've got an obligation, a commitment from the bank, now you can start entering into contracts. Because the last thing you want to do is sign the bottom line and then not have the funds to back it up when the association is still obligated to move forward. Any questions on any of those points? All right, last slide, legislation. So there were some attempts. The Washington Condominium Act first came out in 1990, and it's been amended, I think, about 5 or 6 times since then. A lot of it from the building industry trying to stem the flow of construction defect lawsuits. That pretty much has died out. The legislature said, we don't want to, we've tinkered with this enough, we don't want to deal with the Condominium Act. There was a reserve study law that went into place I think in 2007. I think that the dust has settled on that now, and I think it's taken a little while, but people understand now what that is. That's for condominiums only, required by statute, either old act or new act. It's not required for HOAs, but it's recommended that HOAs also do reserve studies, especially if they've got common areas, roads or signage and areas that require clubhouse capital improvements. There was an attempt at a homeowner bill of rights that was going to make that HOA Act that's paper thin more analogous and more similar to the Condo Act. Unfortunately, that died a couple of years ago. We haven't heard any attempts to resurrect it. Personally, I think it would be a good idea. You have more rights in this state when you buy a toaster than you do in a home. It's pretty bad. So in addition to just warranty rights, it would just make the Homeowner Association Act, all the governance issues and all the governance provisions, management provisions, protections that are in the Condo Act, in my mind, should flow to single-family residences as well. And then lastly, as Michelle talked about, there is a movement for manager accreditation and licensing, slated for 2012, but they're starting to work on it now. And for these last couple points on the Homeowner Bill of Rights and the manager accreditation, I highly recommend you all as board members, as homeowners, get involved. If it's something, look at, stay tuned, And if it's something that strikes a chord with you, there's nothing more compelling, I repeat, there's nothing more compelling in Olympia than for individuals that you're not, a business person, you're not a paid lobbyist, you are a citizen, you are a resident, go down to Olympia or at least sign something. So CAI does have a legislative action committee. It's quite a robust committee. They stay the fingers on the pulse, and once again, CAI is about advocating for homeowner rights, at least that in the legislative capacity. So stay tuned. If you become a member, you'll probably get some alerts. You can look at the website even if you're not a member. And if you see something that's coming up, a Olympia Day or Legislative Day or committee meeting, once again, I highly recommend. We've done some legislative work in our firm, and I can't stress enough how much weight an individual, if one of you were to go down to Olympia and testify at a committee hearing, or just email your senator or state representative, it carries a lot of weight. So with that, I've finished my very quick 5 L's of the legal work. I'm happy to answer any questions. Yes?
Now they have the reserve studies, they started in 2007. Do they have a cap on that when everybody has to have the money in the reserve study in their account?
Okay, the money in the reserve account part of it that's where it kind of fell back. It doesn't have a lot of teeth.
But no, we have a reserve study.
Yes.
We do have money in the reserve, so.
Well, what the law was said annually, and then there was a question, well, does that mean you've got 12 months once the law was adopted? It was some gray area and different interpretations. But the bottom line is that the law now has been effective for over 3 years, so you should.
We keep contributing to it,
Yeah.
and we don't think we're contributing enough. But we are doing it
Yep.
annually,
Good. Okay.
so.
Yep. As long as you've got 2 separate accounts and you are funding it. Okay.
Thank you.
Yes?
Earlier when we were talking about our shows, we mentioned the website that I can access. Would you tell me what that is?
I'm sorry, for website for what?
Website to access to CFR Association.
Oh, sure. I don't have the actual URL, but if you just do a Google search on Secretary of State, Washington, you'll get the homepage, and then just look on corporation search. Click that, and then you'll see a place where you can just put in your name of your association, and it'll pop up. Well, thank you very much for your attention and for your time this evening. And once again, strongly recommend that you join CAI. It would be great to see you at some other events. Michelle, anything else? All right. Thank you. Have a good night.